Family Medical Leave Act by Nathan Voss. In my current position, I am responsible for scheduling, rescheduling, and call-ins. I deal with FMLA matters on a daily basis, so when I read about it in our text, I thought I would research it a little more. The Family and Medical Leave Act was passed in 1993 to allow employees to take time off from work for family or medical reasons. Not all employers offer FMLA. The company is required to offer if they have more than 50 employees. It allows up to 12 weeks of unpaid family or medical leave during any 12-month period. Before FMLA, women often lost their jobs when they took 4 or more weeks off to have a child. This made it difficult for a mom to work. Also, before FMLA, there was nothing in place to protect jobs when being off work to care for an ill relative. The Pregnancy Discrimination Act, or PDA, was passed in 1978 to protect pregnant workers' employment rights. This prevented discrimination against pregnant women in regards to firing, pay, promotion, or benefits, but didn't allow time for moms or dads to be off after the baby was born. FMLA was originally drafted in 1985 by Donna Lenhoff. She proposed 18 weeks over a 2-year period for unpaid parental leave for the birth, adoption, or serious illness of a child, and 26 weeks of unpaid medical leave for the employee's own serious health condition. Compromises were made to the FMLA was signed. George and Vicki Yandel lost their jobs to care for their 17-year-old daughter Dixie, who lost the fight to synovial cancer. George Yandel lost his job as an Oldsmobile salesman. His sales were down because he was caring for his daughter. And Vicki Yandel was fired from her receptionist position at a furniture store after asking for a leave of absence to care for Dixie. The Yandels lost their jobs before FMLA was signed, and Vicki is a huge advocate for FMLA. Vicki was on stage with Clinton when he signed the act. In October of 2008, President Obama signed the fiscal year 2010 National Defense Authorization Act. This law provides new FMLA rights for employees with family members serving in the military. With this extended FMLA, up to 12 weeks of leave for families of military duty soldiers on active duty and are deployed overseas in order to manage qualifying matters. Also, this expansion of FMLA provides up to 26 weeks of caregiver leave for employees needed to care for family members in the military with a serious medical issue that began in the line of duty. In this case, Hibbs was fired when he failed to return to work to care for his ill wife. Hibbs worked for the Nevada Department of Human Resources in the Welfare Division and requested FMLA leave to care for his injured wife. He was given 12 weeks of intermittent FMLA leave over an 8-month period. However, during this period he changed his intermittent leave to full-time leave. The Department of Human Resources claimed he had exhausted his FMLA before the end of the 8-month period and was given a date that he must return to work. He didn't, and was fired. Hibbs sued the agency claiming violations of FMLA. This ended up going to Federal Court of Appeals, and it was concluded that state employees may recover money in a federal court in the event that a state fails to comply with FMLA. Currently, FMLA only applies to employers with 50 or more employees. As time goes on, I expect that FMLA will apply to all employees, regardless of the size of the company. Currently, FMLA allows unpaid leave. Other countries provide paid leave when caring for family. FMLA may eventually pay a percentage of wages during the off time. With a growing workforce and likely increase in FMLA usage, one can expect that regulation of the policy is strictly enforced. Employers will likely request doctor notes confirming correct usage of the time off. FMLA fraud is illegal, but unfortunately happens every day. FMLA fraud is illegal, but it happens all the time. In this case, Mossad Sharif was given FMLA for severe anxiety and was on vacation with his wife in South Africa from March 16th to April 4th. He was scheduled to work in the District of Columbia on March 30th. On the day he was scheduled to be at work, he called work from South Africa to use FMLA, when he was actually missing work for his personal vacation. The following day, he and his wife flew to Italy, returning to D.C. on April 4th. The employer noticed that his FMLA leave was taken in the middle of his vacation, and an investigation occurred. Sharif resigned to avoid termination, but then attempted to sue United Airlines, arguing that the employer retaliated against him for using FMLA leave. There were several facts that supported fraudulent FMLA usage, and Sharif lost his case. Case of Jones versus Gulf Coast Healthcare, 2016, Rodney Jones was fired for abusing FMLA. Jones was the activity director for Essentia Health, a long-term care facility. He took 12 weeks of FMLA leave for a shoulder surgery and recovery, but he was still not able to return to work, and his doctor recommended one more month off. Essentia approved the additional month off as a non-FMLA leave of absence, and during the final days of his FMLA and during the additional leave, Jones posted photos from vacations during this time frame on social media, including photos of him swimming in the ocean during the time he was supposed to be recovering. Jones was terminated when his employer saw his social media posts. Jones sued Essentia, alleging that Essentia was retaliating against Jones for using FMLA. The court quickly dismissed Jones' legal arguments and dismissed the case. With a growing workforce, employers are going to see more and more FMLA utilization. It is important to be familiar with the laws and regulations and to understand employee rights. It is also important for an employer to recognize the possibility of FMLA being abused. When used appropriately, FMLA can secure a sense of importance and value amongst employees.